I didn't send it.
Go through the book.
Address is on the.
I'm sorry, who's on again? Here, Larry. Thanks.
Nice to meet you, sir.
Special breed. It does, but
Excuse me.
it does sort of die into it.
I've got my old hickory stick. I'm sitting. Let's see if the jury can see it all. I'm right here. First, I'll use the old hickory stick. I know. So, Paul,
Yes.
you swear?
Yes, we're square, Mr. Jake. That's the only slide I have to open. So.
And Drew, are you going to have anything?
Hey,
It seemed like a
Yeah.
Yeah, I got it. Here.
When it pulls out.
Well, you found one. I didn't have time to put in something.
Put on the roll, and when you turn the jury in, you're going to begin with preliminary inspection. We don't know.
We have 13. We don't know who the alternate is, but somebody's going to be sitting up front.
Let me get clear, because I would,
Personal.
yeah, I think, I would,
Let's set it here, right here.
that's where I put them before. Put them just to the end of the second.
Perfect.
Great. And if you want to get these other chairs moved, you move them.
I think they're fine.
For openings, and then tell Claire if you don't want them there for tomorrow. All right, when I come back, are you ready? Eric, we'll probably go in about 5 minutes.
Good for me.
beginning of your opening, when do you want
Yes.
that?
When I have it, I don't know if you're referring to it.
So when I introduce you, I should put on the screen.
Yes, sir.
I'm gonna read the file information first, Your Honor.
Again, we're waiting for, I think Claire was trying to determine if all the jurors are here. Not yet, we're waiting. She was gonna confirm and come back.
So you want us to stick them in like the window?
Oh, yes, if you, I'm sorry, you did, Mr. Brammer?
Yes.
Yeah, bring Mr. Brammer, I'm sorry. Please be seated, folks. We're back on record after our lunch and recess. At this time, ladies and gentlemen, I'm going to provide you with a number of preliminary instructions. We'll finish with those instructions, and ask the county attorney to read the trial information, and then you'll hear opening statements from both the state and the defendant. At this point, I'm going to give you my preliminary instructions, and I'd ask you to give me the floor. Members of the jury, excuse me, throughout the course of this trial, we'll be hearing witnesses testify about events that form the basis of this case, and exhibits may be received as evidence. Since you, as the jury, are the judge of the facts, to better enable you to understand the evidence and testimony as it is received, and to apply it to the law, at this time, I will provide you preliminary instructions on certain matters. Instruction number 1. Personal prejudice have no place in court. You must set aside and disregard any personal feelings of bias or prejudice which you may have based on sex, race, religion, national origin, age, or disability. You must decide this case only on the basis of the evidence which is admitted in the law, as I explain it to you. My duty is to tell you what the law is. Your duty is to accept and apply this law. Your duty is to decide all fact questions. Do not be influenced by any personal likes or dislikes, sympathy, bias, prejudice, or emotions. The trial information charges the defendant, Ivan Samuel Brammer, hereafter referred to as the defendant, with the crimes of murder in the second degree, abuse of a corpse, and theft in the second degree. Instruction number 3. The trial information is the document that formally charges the defendant with a crime. It is merely the method by which the defendant is brought into court for trial. It is not evidence. Instruction number 4. The defendant has entered a plea of not guilty. The plea of not guilty is a complete denial of all of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you, the state must prove something. It must be by evidence beyond a reasonable doubt. Instruction number 5. The defendant is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which you might have that arises from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 6. The burden is on the state to prove the defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. If, after a full and fair consideration of all of the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt, and you should find the defendant guilty. But if, after a full and fair consideration of all of the evidence, or lack of the evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt, and you should find the defendant not guilty. Instruction number 7. You shall base your verdict only upon the evidence in these instructions. Evidence is testimony in person or by videotape deposition, exhibits that are received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received in evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers. Objections and rulings on objections. Any testimony I tell you to disregard. Anything you saw or heard about this case outside the courtroom. Instruction number 8. You will hear testimony from persons described as experts, persons who have become experts in the field because of their education and experience, may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other evidence or testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons, and all the other evidence in the case. Instruction number 9. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all of the evidence the weight and value you think is entitled to receive. Instruction number 10. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence. But if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe. Whether a witness has made inconsistent statements. The witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. And the witness's interest in the trial, his or her motive, candor, bias, and prejudice. Instruction number 11. You must decide this case based solely on the evidence received in this courtroom. This means that during the trial, you are not to do any independent research about this case, about the issues presented, and about the persons involved in this case. In other words, you must not consult dictionaries or reference materials, search the internet, websites, blogs, or use any other electronic tools to obtain information about this case or to help you decide this case. Do not try to find out information from any source outside the confines of this courtroom. You are not to Google the lawyers, the parties, the witnesses, or even me until after you've reached a verdict. You must not talk to anyone about this case. I know many of you use smartphones, iPhones, the internet, or other tools of technology. You may not use any of these devices to communicate through email, text messaging, on Twitter, through a blog, internet chat room, or by way of any other social networking websites, including Facebook, LinkedIn, YouTube, etc. Ladies and gentlemen, I want you to understand why these rules are so important. Your decision must be based solely on the testimony and other evidence presented in this courtroom. And as I stated to you, the admonition following your oath, our law does not permit jurors to converse among themselves about the case until all of the evidence is submitted and you're instructed to begin your deliberations. These rules are designed to help guarantee a fair trial. And our law sets forth serious consequences if these rules are not followed. Failure to follow these rules may jeopardize the results of this trial, causing the matter to be retried, and or you could be held in contempt. Consider your parent, child, sibling, or close friend was a litigant. You would want all jurors to follow the rules. Please join me in protecting the process. At this point, in a few minutes, I'm going to turn to Mr. Welber, who's going to read the trial information, and then he'll be followed by Mr. Forney making opening statements, and then when he's done, Mr. Munger is going to make an opening statement. The opening statement is an opportunity for the attorneys to let you know what they believe the issues are and what evidence they think will be received. Please remember that their statements and their arguments that they'll make to close the case, that's not evidence. I just gave you that preliminary instruction. But their statements at this point in openings is an opportunity to give you an outline of what they think the evidence will be. Sometimes evidence comes in out of chronological order. It's an opportunity for them to help you navigate through the evidence. And I'd ask you that you give all counsel your attention. Mr. Wilder, if you read the trial information, please.
Thank you, Your Honor. In the District Court of Potawatomi County, Iowa, at Council Bluffs, State of Iowa versus Ivan Samuel Brammer, case number FECR 171749. Trial information. Comes now the County Attorney of Potawatomi County, State of Iowa, and in the name and by the authority of the State of Iowa, accuses Ivan Samuel Brammer of the crimes of count 1, murder in the second degree, count 2, abuse of corpse, hide or bury, count 3, theft, second degree, committed as follows. For that the said Ivan Samuel Brammer, on or about the 13th day of February, 2023, in the said County of Potawatomi and State of Iowa, count 1, did with malice aforethought kill Ilene Gowan. Count 2, did abuse a human corpse by hiding or burying it with the intent to conceal a crime, or fail to disclose the known location of a human corpse with the intent to conceal a crime. Count 3, did take possession or control of the property of another, the property having value in excess of $1,500 but not exceeding $10,000, with the intent to deprive the other thereof. Against the peace and dignity of the State of Iowa, and contrary to statutes and cases made and provided in violation of sections for count 1, 707.1 and 707.3, count 2, 708.14 sub 1b, 708.14 sub 2, and 903b sub point 2, and count 3, 714.1 subsection 1, 714.2 subsection 2, all of the 2022 Code of Iowa, true information. The defendant has entered a plea of not guilty to all 3 charges. Thank you.
Mr. Forney?
Thank you, Judge. May it please court.
Counsel?
Counselor. Ladies and gentlemen of the jury. Her name is Ilene Gowan. She was 60 years old. She was a daughter. She was a sister. She was a mother. And she was a grandmother. Ilene went missing for about 2 weeks until her body was found. She was found about approximately 8 miles north of Council Bluffs in a remote area, an area that's commonly known for people dumping their trash. There she lay. She was dumped, just like the trash that lay next to her. She was wearing the exact same clothes that she was wearing 2 weeks prior on the day she went missing, on Monday, February 13th, 2023. This case is about jealousy. It's about anger. It's about control. It's about a man who for 2 weeks had no concern about Ilene being missing Why? Because he already knew she was dead. Ilene and the defendant had a very complicated relationship. It was volatile at times. It involved alcohol sometimes. They had verbal disagreements. We will have witnesses in the way of family, friends, co-workers. They will all testify to that. It was a complicated relationship. But this time it was a little bit different because when they broke up this time, she was staying with another man. And you have to understand they were an on and off relationship for a year and a half. A week before Ilene's disappearance, the defendant and Ilene had broken up again. They were no longer living together, and Ilene was staying temporarily at a friend's house. His name was Mike Brockman. He's an individual that Ilene knew from the bar called Sugars. Sugars will be brought up throughout this trial. One reason why is because Ilene is seen leaving Sugars at 8:30 in the morning with the defendant in his truck from Sugars parking lot. And that was on February 13th, 2023. Sugars is located right over here off Kingsville Boulevard. Mike Brockman's house, or residence, is located right up here, just north up on Railroad Highway. That's about 2.5 miles. You see, Mike knew that there was a little bit of drama going on between Ilene and the defendant. He was nice enough that he was going to allow her to stay there for a while. She ended up staying there with him that weekend before she disappeared. But Mike Brockman also knew that there was drama. And Mike told Ilene that she couldn't stay there anymore. She just couldn't. He didn't want to be part of it. So the plan was for, on Monday morning, the 13th, Mike Brockman was to drop Ilene off at 5:30 in the morning. She has an early cleaning shift that she does at the bar. And then later in the evening, when Mike is back from his job, he wanted Ilene to come back and pick her stuff up. Now, when I say her stuff, I'm talking about literally stuff that would fit in a 2x2 box. It wasn't much. So both the defendant and Ilene worked at Sugars. The defendant was a dishwasher, and Ilene worked the early morning cleaning shift, and she also would pick up shifts in the afternoon as well. So on that February 13th, Mike Brockman does drop Ilene off at Sugars. So Mike Brockman drives from his house down here to Sugars, drops her off at around 5 o'clock to 5:30 in that time frame. And then he drives off to his work, which is in Omaha. At the end of Ilene's cleaning shift, which was somewhere around 8 o'clock, she calls her daughter, Nicole. Nicole will come and she will testify in court. She called her daughter, Nicole, adult daughter, at 8:06 a.m. And that was the very last conversation Nicole had with her mom. Ilene also talked to the defendant. She messaged him, and then there was a phone conversation about that same time with the defendant. And Ilene asked the defendant to come pick her up from Sugars. Even though they were broken up, they had this on and off relationship going on. So he does. He does exactly that. He comes to Sugars at 8:30 in the morning, and we will have video from Sugars showing the defendant arriving at 8:30 in his dark blue Ford F-150 pickup truck. Ilene can be seen as a passenger leaving in his truck from the video at 8:32 a.m. Ilene was supposed to come back and work an afternoon shift at 2 o'clock. But she didn't show. And that was unusual. The owner of Sugars, her name is Megan Preston, and she will testify that Ilene was a reliable worker. She will testify that she's the type of worker that if she wasn't going to show up, she would text or call to let her know. She will also testify that they were in good communication. They texted often. It was a pretty good relationship in terms of boss and employee. They had good communication. Moreover, her family will testify that she had good communication with her family members as well. She was the type of person that would contact her family members, whether it be a call or a text, especially Nicole. Nicole, one of her adult daughters, she will testify that she talked to her mom every day. So Megan, Ilene's boss, is working at Sugars. And she's trying to get a hold of Ilene because she's covering that shift, and she needs Ilene to come pick up her 2 o'clock shift because her boss was actually working the shift before. So she sends a message, text message, and calls Ilene, nothing. 2:20, she sends a message to her, and finally, at about 2:44 p.m. in the afternoon, Megan receives a message back from Ilene's phone. But there was something different about this message. The message was odd to her. It did not sound like Ilene. They had established a good communication with text messages, and there's something about that message that just wasn't right. Now the defendant, he didn't work on February 13th. He didn't work on February 14th. And he was scheduled to work on February 15th. But he failed to show on February 15th. And in fact, when law enforcement was interviewing him, his first interview was on February 15th. And he will even state in the interview that he didn't call in and he was probably fired. And that was unusual behavior for him. For nearly 2 weeks, law enforcement is investigating this case. It's a missing person. They're doing everything they can to find Ilene. In those 2 weeks, officers were interviewing many people. They interviewed family. They interviewed friends. They interviewed coworkers. Law enforcement canvassed the area. They were trying to pull video from businesses, local businesses, from the intersection cameras with the public works. They were doing everything to try to figure out where she went that day. They were trying to find Ilene. They even applied for search warrants for people to try to get their phone information so they could get something back and try to get a lead on where she was, where she went on the 13th. But before getting all that information back, there was something about the defendant. There was something abundantly clear about the defendant. That each and every time law enforcement talked to the defendant, his stories changed a little bit. And as law enforcement starts getting some of the facts back, or starts getting some of the information back from their investigation, they start figuring out these stories aren't lining up. In fact, we'll talk February 15th, his first interview with Sergeant Roberts. The defendant says he picked up Ilene, 8:30 at Sugars in the morning. He drove to Mike Brockman's house, which, as you know, is only about 2.5 miles away. Never sees her again. Goes back to his apartment. His apartment is Cottonwood Apartments. So they're over here. So he picks her up at Sugars, 8:30, 2.5 miles up to Mike Brockman's house, drops her off, drives back down, goes down Broadway, and goes to his apartments, Cottonwood Apartments. Mentions nothing else about any other stops or anything else. Now, he does also talk about that when he dropped her off, he went back to his apartment, and strangely later that morning he got some messages from her, and then he heard some knocking on the window, And he thinks it was Ilene, but he didn't answer. But the fact is that when we were starting to get the surveillance camera information back, we knew that on the 15th that story was not true. Fast forward February 17th, 2 days later. Now keep in mind, the 15th is only 2 days after she goes missing. Only 2 days after he saw her. And he's leaving out all this information. The second time he was interviewed was February 17th, which is another 2 days. So we're 4 days out now. Well, defendant's version changes. Now his story is that there's more detail, and now he goes to Sugar's. So he picks her up at Sugar's, Ilene, and then decides to drive over to Dudley Court. Dudley Court is the residence of Ilene's mom. She lives in an apartment there in Dudley Court. So the defendant says he takes her over to Dudley Court to see her mom. She goes into Dudley Court, gets a black safe that she keeps at her mom's, and another personal item, I think a purse. And then they're there for about 5 or 10 minutes at Dudley Courts. And then he drives back and drops her off at Mike Rockland's residence and never sees her again after that. Now, at this time, officers already know that he's not telling the truth again because they've received information that he was actually heading west out on 36th and Broadway like he's going over to Omaha. And they confronted him about that. And he denied it. Said he never went to Omaha. Didn't remember going to Omaha. Keep in mind, this is now 4 days removed from the day that she was missing. Law enforcement may have learned some truthful facts about that interview, but the fact of the matter is his version of the truth was not correct. It was untrue. February 24th, another interview with law enforcement. After being arrested on a looting case, the defendant agrees to discuss Ilene with the detective. Now he admits to going to Omaha. He says, yep, I went to Omaha to get some cigarettes. Moreover, he says he ends up stopping at Carter Lake. Carter Lake is right here. It's in Potawatomi County, it's right here. He says that he stopped at Carter Lake, in his words, for a little bit of fun with Ilene. Then he says he takes her back down Broadway and drops her off at Mike Brockman's residence. The law enforcement knew he was lying again because now we're getting more information back. Now we're getting information that the defendant was clear out in Trainer, which is 14 miles away from Council Bluffs. Never mentions anything about Trainer. Yet another version that's untrue. The defendant continually changed his story as he learned that law enforcement had video of him in certain locations. He was changing his statement to conform to what law enforcement knew. The video evidence in this case will demonstrate that none of the defendant's versions of the story of what happened on February 13th were correct. There was some truth to it, but it was just bits and pieces of truth. The evidence is the truth in this case. The state will present the route the defendant took that morning on February 13th, 2023. You'll see the locations, you'll see the times. You'll see video, you'll see photos of them together in a couple different locations. You will see the exact clothes that she's wearing that morning. The distinct pattern on her green sweater, her jeans, her coat, her shoes. You will also see a black safe. You will see a video of her walking down Dudley Court with a black safe. You will also see a video of her at Burger King drive-thru. It'll be the drive-thru window. There was a video there. And this is at 10:30 in the morning. And this is February 13th, 2023. And you see Ilene in the passenger side, and she doesn't move the entire time. Her motionless body is sitting in the passenger side, and she's in a very awkwardly stiff position the entire time. You will see that on video. You will learn just how untruthful the defendant was with his interviews. Now, the defense may offer some evidence about Mike Brockman or something about it could have been Mike who was potentially the one related with this investigation, but law enforcement thoroughly looked at Mike Brockman. In fact, Mike Brockman's going to testify. We expect he'll testify tomorrow morning. Mike Brockman will. The law enforcement interviewed Mike Brockman, did a phone dump, talked to his employer. Mike Brockman was working all day February 13th and all day on February 14th. Now, I anticipate the defense will probably bring in some evidence about alcohol, that she was drunk or was going through withdrawals, but you can see from the videos, there'll be two very distinct videos where you will see Ilene walking that morning. One of them will be at 8:30 in the morning when she walks into Sugars, so she went outside for some reason and walked back in Sugars, and you will see her walk. It's a normal walk. It's not a long clip, but you can see her walking. But the better video is Dudley Court. Dudley Court is at 8:51 a.m., and you will see her walk down the hallway carrying her safe, walking right down the hallway like a normal person. She has a normal gait. She has normal balance. And it will disprove this defendant's theory if they're going to claim that there's some kind of alcohol related to her death. She was not intoxicated on February 13th. The autopsy report will show that. You will see compelling evidence, phone evidence from the state's case. Special Agent Hout, he works with the FBI. The cell phone records from the network provider tell the story. And you're going to see that. You're going to see that evidence. Special Agent Hout from the FBI will testify that both Ilene's phone and the defendant's phone not only were traveling together that morning, which we'd expect them to, but they were traveling together in the afternoon as well. And they were traveling together the next day. Moreover, there will be evidence that will show you that not only were the phones traveling together, because these phones are connecting with the cell phone tower, and they're connecting to the network on the cell phone towers, but there will also be evidence that later in the day on the 13th, that these phones in certain situations are being manually shut off and turned on at the same time. The defendant's own granddaughter, Emily, she resides in Cottonwood with her grandfather, the defendant. Her name is Emily. It's his own granddaughter. She will testify that she believes she saw her grandpa, the defendant, with Ilene's phone after she disappeared. And she will be able to testify as to what the phone looked like. She's going to testify that it was distinct. It was a pink casing, and she knew it. And she will testify to that. The defendant will have no explanation for why he would have Ilene's phone.
Your Honor, may we approach?
You may.
evidence of suspicious and unusual behavior that the state will offer as evidence that you're going to see. And I will just list them. Number one, the defendant didn't show up for work on the 15th, and it was unlikely for him, or unlike him, to not show up for work. Number two, he crushed his F-150 pickup truck for $750. Evidence will show that it was likely worth around $5,000 to $6,000. The defendant pawned a sentimental studded diamond earring that was given to him by Ilene. Evidence will also show that the defendant deposited $1,200 cash, the amount thought to be in the safe, 2 days after her disappearance on February 15th. Number five, there will be evidence that he eluded law enforcement, that law enforcement chased him with lights and sirens as he sped off into Omaha. Number six, Emily, his own granddaughter, called law enforcement because he was making suicidal statements. And so law enforcement had to go meet with him and take him over to the hospital to make sure that he was safe. The defendant also, when he returns from Trainer at 12:59 p.m., parks his truck and starts taking items out of his truck and dumping them in the trash. Lastly, you will hear from two medical experts regarding the autopsy of Ilene. First, you will hear from Dr. Cruz. She will testify that Ilene had 8 blunt force impact contusions to the head, a laceration in her left front scalp, multiple contusions on her torso, a fracture of her front upper tooth, and multiple blunt force blows to her extremities. Dr. Cruz will also testify that the body had decomposed enough that it made the autopsy more difficult. And I'll give you an example. Her right eye was missing due to the fact that animals had scavenged on her face. Dr. Cruz will testify that Ilene's body just didn't tell her enough to give her an opinion on whether there was a cause or manner of death. However, the second expert, Dr. Michael Bodden, is a renowned pathologist. He will testify. He reviewed the autopsy, and he will give an opinion that there is a cause and manner of death. He will testify that the injuries, the trauma, contusions, abrasions, all that evidence was evidence of an altercation before she died. Dr. Bodden's opinion is, he will say that the cause of death was traumatic asphyxia due to neck compression, and manner of death, homicide. At the conclusion of the evidence, it will be clear that the state has proven this case beyond a reasonable doubt that the defendant murdered Ilene. He took $1,200 of her cash and her phone, hid and moved her deceased body to a remote location, dumped her in the ditch like she was a piece of trash. At the end of this case, I'm going to ask you to hold the defendant accountable for his actions. You will be firmly convinced that the state proved this case beyond a reasonable doubt. I ask you to find the defendant guilty on all charges.
Counsel? Mother?
Hey, please report.
Counsel?
Counsel. The 5 W's. You might remember this from 8th grade English class. Who, what, where, when, and why. Those are the questions that you need to be thinking of throughout this case. Because the state, like an 8th grade essay, is going to try to paint you a picture, try to tell you a story about what happened to Ilene Gowan. However, unlike 8th grade English, this is not just a story. This is something the state has to prove beyond a reasonable doubt. We talked about what beyond a reasonable doubt meant during a jury selection. I feel that you all know what that means. So let's start off with the who. Pretty simple. We have the alleged victim, Ilene Gowan. And I'm calling her alleged victim, not because I'm trying to seem blasé about it, but the fact is, we don't know how she died. It could have been an accident, it could have been another cause. So that's why I'm calling her the alleged victim, Ilene Gowan. We have the defendant, Ivan Samuel Brammer. Mr. Brammer goes by Sam, and he is who the state of Iowa has charged with these allegations. What? The state has charged Mr. Brammer with murder in the second degree, abuse of a corpse, hiding a corpse, and theft in the second degree. The state has elements it needs to prove on all three of these charges, and they each have individual elements. But that is what the state needs to prove to you beyond a reasonable doubt. Where? The state showed you their nice map of all the points of interest that they have on this case from Monday, February 13, 2023. We have video evidence of Mr. Brammer picking up Ms. Gowan at Sugar's at around 8:30 in the morning. They have cameras and video tracking them all through the town of Council Bluffs, and then they lose them as they are getting into Omaha. There's going to be some testimony that you're going to hear that they were in the Carter Lake, Omaha area, probably picking up some cigarettes because they're the cheapest in the area. Then we have cameras getting this dark blue truck coming back into town from the 480 interchange. We have them stopping at Burger King. We have them driving past a bank with some cameras at the ATM so you can see the truck driving by. The state had nearly everything that they needed to track Mr. Brammer and Ms. Gowan throughout town. But what they can't tell you is how she died and where she died. They're going to tell you, oh, she must have been killed on Railroad Highway. Or, according to the state, just in his opening statement, she was motionless and not moving at the Burger King drive-thru. This is the Burger King drive-thru that is the first Burger King coming into town on West Broadway, heading west. The state is going to want you to believe, through their evidence, that she was killed sometime between 8:30 and 10:30 in the morning, driven all around town on a Monday morning where there are plenty of cars that you'll see on camera driving by, and then taken to Mike Brockman's residence, and then taken all the way back through town, and then, if you don't remember from the map, you'll see later, the crime scene, as they're calling it, is up north by the Old Norman Bridge. This is where she was allegedly dumped. You are never going to see any evidence of Mr. Brammer heading towards the Old Norman Ridge Road to dump that body, as the state would like you to believe. When? The state's allegations, again, all stem from February 13th, 2023. You're going to hear testimony that some people may have seen Ms. Gowan at Sam's Club. You're going to hear on February 14th. You're going to hear testimony that some people may have seen her at the food pantry on February 14th. You're going to hear that some people may have even thought she was in Louisiana at a mental health ward. These are all incidents that occurred after the state's allegation that this happened on February 13th. Why? You heard the state say that this is a volatile relationship. You're going to hear testimony that Sam was the one who told Ilene to move out of his apartment, his granddaughter's apartment. He wasn't the one who was kicked out. He wasn't the one that was upset about her leaving the apartment. He was the one who asked her to leave. You're going to hear testimony that Ms. Gowan was a little bit dramatic, and that she was trying to get a rise out of Sam at different points, especially when she was staying at Mike Brockman's house. I want you to pay close attention to what Sam did in response to these provocations, or maybe a little less than a provocation by Ilene, but in her attempt to start some drama. Finally, and I'm not sure when they added this to the 5 W's, but I think when I was in school, there was a 6th W that was not even a W, and that was how. How did this all occur? we have the Iowa State Medical Examiner's Office that is going to come in and testify. And they're going to tell all 13 of you that it is her expert opinion that she does not know how Ilene Gowan died, and she does not know what caused her death. She's not going to be able to tell you when she died. This is a person who will testify that she's performed thousands of autopsies and works in an office that performs thousands of autopsies across the state. Unhappy with this information, Ms. Gowan's family contacts Dr. Michael Bodden. And you'll hear Mr. Bodden or Dr. Bodden testify, and you'll get to weigh what Mr. Bodden has, or I apologize, Dr. Bodden has against the Iowa State Medical Examiner's Office. And I want you to pay very close attention to what Dr. Bodden has to say, as compared to what the Iowa State Medical Examiner has to say, Dr. Kelly Cruz. The state can talk about waking up to freshly fallen snow, or it's a puzzle with a few missing pieces, but you can tell what the picture is. But that's not what the court of law is about. They're here telling you a story. And the story with the 5 W's, who, what, where, when, and why, they can't prove to you beyond a reasonable doubt. And that is their burden. And most importantly, they cannot tell you how Ilene Gowan died. It certainly could not have been by murder. So when you go back into that jury room, after hearing all the evidence throughout this week, I feel confident that you will come back with the only just verdict, that Ivan Samuel Brammer is not guilty of all charges. Thank you.
Thank you, Mr. Mubber. Ladies and gentlemen, that concludes the opening statements by counsel. It's 3:15. You've been working hard with me all morning and now in the afternoon. And at this point, I think it's best if we take an afternoon recess and then return tomorrow morning to begin hearing testimony. So we'll be in recess from today, or from here in a few moments, until approximately 9:15 tomorrow morning. I'd ask that you all return to the courthouse around 9 o'clock. And so if I wrap up a couple of the things I need to that are unrelated to this case, then we'll be able to get going right at 9:15 or shortly thereafter. As I have stated before, you're going to be going home, and they're going to ask you, so what did you do in court today? And you're going to have to tell a significant other or family member that I can't talk about it. Because Davidson said I couldn't visit with you about anything. That'll be each night you go home. So please remember that admonition. Keep an open mind. I thank you for not bringing any big gulps, and so you've got any water bottles or something small. It's November, so we have temperature changes. It was pretty warm in this courtroom this morning. It's quite warm now. Tomorrow, it'll be warm again. It could also get chilly. So wear some layers. And with that, we'll be in recess until 9:15 tomorrow morning. Thank you.
Please rise.
Please be seated, folks.
We're on the record out of the presence of the jury. The court wants to make some brief record on the sidebar. I'll state my summary and my ruling, and then I'll allow those counsel an opportunity to make whatever record they choose. The one sidebar we had during opening statements was requested by Mr. Munger. At that sidebar, he voiced an objection. In his view, the prosecutor in his opening statement was burden switching, and Mr. Forney responded that he believed the statements were appropriate and they were not burden switching. The objection was overruled. However, the court advised Mr. Forney that it was the court's opinion the statements were approaching what could be viewed as burden switching, and any further statements must be avoided, or he'd risk another objection that may be made without sidebar. And the court then ruled and would be admonished to the jury. The court also, before concluding the sidebar, further advised Mr. Forney that the court believed that his opening was, if it hadn't crossed the line, was approaching crossing the line into argument, and that should be avoided as well. That is a summary of the court's sidebar, the court's ruling, and statements of counsel. Beginning with the prosecution, Mr. Wilbur, Mr. Forney, any additional comments concerning the sidebar?
I believe you accurately summarized the discussion. It's the sidebar. I would just certainly note, I probably think the defense might have approached argument during their opening statement as well. I think probably that's fair commentary based on the state's opening statement. Without the objection to it, just noting, I certainly heard some things that I would have said might have approached the same.
Thank you. Mr. Munger?
Judge, I believe that you summarized the sidebar appropriately. At this point in time, remedial measures, we are not asking for mistrial, but I believe a cautionary instruction to the jury would be appropriate, stating that something to the effect that the defense has no burden of proof in this case, and that any statements regarding any anticipated argument by the defense not be considered by the jury. The court's made its ruling on burden shifting, so I have nothing further on that.
Counsel, with respect to your request for further admonition, the court actually considered it as you all were returning to your seats, but I remind counsel, I had already provided this jury with preliminary instructions, which include the burden of proof, and those instructions are very straightforward, and I'll be providing those very instructions at the close of this case, as you all are well aware. I'd also note that as part of my instructions, I'll be reminding them that statements made by counsel are not evidence, and that they need to, in fact, there's further instruction that actually states what is not evidence. One of those comments is statements made by the attorney. So I'm ruling now that I'm denying your motion for further admonition because I've already instructed the jury on those two very same and important points, and I'll be instructing them again. If there's something that comes up in the trial on either some type of either burden switching or some other inappropriate comment, I may, sua sponte, offer my own further admonition from time to time. I do that based on how the evidence comes in, or a statement by counsel, maybe a speaking objection, but counsel might be one of those. So, unless there's anything further by either party, I'll turn to the state any further.
I just know, Your Honor, I think I was crystal clear during jury selection that anything that has to be proven in this case has to be proven by us, the state. The defense has no burden to prove anything. I don't put any witnesses on. I don't put any exhibits on, they don't even have to cross-examine a witness. I don't think I could have been clearer about that. So that, in combination with the court's instruction before trial and I trust afterwards, I have no objection to an additional instruction, but I believe that the court has adequately set forth the law as far as the jury's concerned already.
Yes. Mr. Margaret, anything else?
No, Your Honor, thank
All
you.
right, good enough. Record made. We're off the record. We'll be in recess until tomorrow. I might ask counsel to meet in chambers to talk about logistics. Right now. Tuesday, I'm going to come back out and address some of the rest of the stuff. So that there's stuff here. No, I think
I didn't use my gap time. I wait until the I will always use that.
Hi, how are you? Good.
Yep.
Are you locked out? Huh.
That's a switch.
It's a little earlier. I'm gonna do some work here and I'll be back there in a minute.
Ma'am? Probably ask. This speaker wasn't on, and I'm trying to get the, I don't want to shoot a mic over people speaking. I was wondering anyway if we can find out why, if that speaker was on, or if we could turn it up, or
I don't know. You might have to ask Clara,
Clara.
the girl with the long hair.
Yeah, I'll speak.
I thought you were into our mic system. You're not?
No, they won't let me.
Oh, I thought you were.
Well, that's what the court order said. Nothing will be allowed to gain any audio from the court area. If I can get into the mic system, I'd be happier.
I thought that's what it was.
Uh-huh.
I guess ask her maybe.
Because I asked her, I was like, "Do you have an XLR?" Because that makes my life so much easier.
Oh, so you're just using that to try
Yeah,
to get
well, right now,
sound?
what I was going to do is what I did in lacrosse is I angled it up towards the speaker because she said I could have a mic on there, but I couldn't get anything in there. And I'll talk to her again, but it said just nothing that would be able to record anything from the table. So she's making it sound like they're worried about
Oh, I see.
the lawyers, the counsel.
But if they turn their things off, you don't
That's
get
what
it.
I'm used to.
Yeah, I thought I understood the judge say you were in the mic system, so I'll check with him.
If not, if I can be, please let me know because I would
I'll go
definitely.
ask him right now and then I'll come back.
Okay.
Okay, I'm gonna lock up in here.
I just had one question.
Yeah.
This speaker, because we're trying to get
You know
this
what?
set.
Yeah, so here's what happened is the judge didn't have it on up there. He had his on, so I let them know that we need to
Okay.
have those on in the morning. I'm gonna test them because I'll
Okay,
get here
but I
before
could have it
everybody.
pointed here, right?
I think so.
Because the lady that's the stenographer,
yeah.
she mentioned she thought we were in the mic system, but I told her we couldn't.
So
be.
you should. So if I turn this on, you should be able to hear sound there.
Oh yeah.
But even then, you should be able to. I mean, if I turned it on, you should be able to hear it pretty well back
Yeah.
there as well.
That's what I was hoping.
You know what I'm saying?
So that's. I was just wondering if you could keep talking and I could do this so I could set the sound.
You're just testing it. Is that what you're trying to do?
Yes, ma'am.
Okay, because I don't know if it would make that weird noise.
Oh, it won't.
Oh,
'Cause
okay.
It's going out. It's going out through my my audio.
Yeah, we're testing
We're
it.
testing it.
Okay, because the light people are commenting on the live stream saying that they're hearing everything that's being said in this room. Still?
Oh, okay. We're testing the audio.
Okay.
You just real simply just talking their passion out.
Did you shut down the live stream?
Yeah, hold on one second.